Hi, I'm attorney Gregory Dell, joined by attorney Cesar Gavidia, and we're going to talk about disability insurance denial options for doctors. And Cesar, it's very different, the disability insurance denial claims for doctors, physicians, dentists, all of the medical specialties that we've handled. And you've handled thousands of these claims, having represented so many doctors all over the country. And one of the things that makes these types of cases really unique is because of the definitions of disability that are commonly found within the policies that are sold to these doctors. And in this video, I want to talk about the issues that we commonly see when we're litigating these cases, what a doctor should expect if their claim has been denied, and then provide some advice about our experiences that will hopefully be helpful to a doctor who finds themselves in a denial situation right now. So the first thing, Cesar, that I'd want the physician to know is, now that their claim's been denied, what are the options that are available to them?
So typically what I do in terms of the assessment that I conduct, the first thing I do, obviously, to determine what do we do next is to request all of the documentation. I do ask for what's called the claim file from the insurance company. Sometimes, because of so many of these policies that are underwritten to doctors are individual disability insurance policies protecting them for their own occupation, the insurance company doesn't necessarily have to hand you over their whole file. They can send you at least the correspondence, though, that has interchange between you and the insurance company. They might not send you all the reports and everything like that. But I do that so that I could understand, let me take a look, an objective look at this claim. Is it lacking something? Is there something that we could do now, all right, that perhaps with a demand letter to the insurance company or an appeal to the insurance company, it could get this claim moving in the right direction. It could redirect the path and get it paid. Because if we do that, we could save, 12 months to 24 months in terms of getting those benefits back and getting our clients paid. Because the other option is basically to potentially head into litigation. And litigation, getting involved with the courts is going to be potentially a year, 2 years, 3 years, even longer potentially in terms of time before you see any benefit payments whatsoever. And that's assuming that you prevail.
And Cesar, just to back you up one step, I know the options considering, would I do an appeal or would you just file into lawsuit? Can you explain for the doctors a situation where they may have to do an appeal because of the type of policy that they have?
So there are a couple of different types of policies, and when you're talking about a doctor, there's doctors who are in an individual practice, and maybe a solo practitioner or maybe in a group with partners. They have their own individual disability insurance, and in some cases they may be insured under a broader group disability policy, a kind of umbrella type of policy that insures the employees or the partners in the practice or everyone. And there's a real clear difference between these policies, because aside from the claims under each policy being governed under federal law or state law, there's also a difference in terms of how the insurance company is going to handle the claim and what they're going to do if they deny the claim, and the notice requirements that are required in one case versus the other, and then your rights after the claim actually gets denied. In the group disability setting, where the doctor may have a policy with the rest of the employees kind of covered under this group disability insurance plan, there's going to be a requirement to appeal. All right, and there's deadlines to that. There's usually about a 180-day deadline to appeal and submit all of the evidence that's going to support you in your disability claim. And it's a really important and critical part of the process, because the appeal really serves two things. The first, obviously, the objective of getting the claim overturned and getting the claim approved and the benefits paid to the doctor. The other is to prepare that case for potential litigation in the future, because in that setting, that federal judge that may be looking at the case and adjudicating the claim and your eligibility for benefits down the road could only review what's been provided to them, to the disability insurer, through the administrative appeal process and through the claim process. If anything is left out, if any critical piece of evidence such as a test, a report, a certain doctor's records don't make it in, a certain issue isn't addressed appropriately or properly that was brought up on denial, then you may forfeit your right to bring that up or bring that piece of evidence in, and that may be that may mean the difference between being paid and winning your case in litigation, or basically being denied and losing your case in litigation.
So, there's clear differences between the claims that are group, which are governed by ERISA, and the individual claim where you can voluntarily do an appeal, try to resolve the claim, or you could just go right to a lawsuit. But clearly in the group policies, you have to file an appeal, and then you can file a lawsuit. So totally different. No right to a jury trial in ERISA, and obviously you can get a jury trial if you have an individual policy. So they're completely different animals. Most doctors, I would say 95% of the doctors we represent, have an individual disability policy, and they may also have a group policy. The issue of the trend we've seen in the last 5 years is that a lot of doctors have been bought by these business groups and consolidated into these business practices, and unfortunately many doctors have given up their individual disability policies because their new employment group gives them disability coverage, and it's a lot cheaper, obviously, and they feel that they're getting $15,000, $20,000 a month in group disability coverage, and that will be enough for them. And so they could get stuck with this group policy. The unfortunate thing about doctors who do that is that if you change jobs or no longer work for that employer, you're not going to have your disability policy go with you. So we deal with the individual, we deal with the group all the time, and the options are there that we discussed about whether it's individual or group. And Cesar, I want to shift gears now a little bit because we see a lot of the same themes for denials of disability claims for doctors. And I'll start off with one that I want you to discuss, which is very common, is when a disability insurance company determines that a doctor is not totally disabled, but they believe that the doctor is residually disabled. Can you explain what that situation is and how it comes about?
Yeah, so it often comes about where, let's say that there's been a condition that the doctor's been dealing with for some time. Let's call it, a spinal arthritic issue or something like that. Something that's been kind of progressive. And they've been working with that condition over a period of time. Then comes a point where they just simply cannot continue working anymore. That it's either become too painful, they're too uncomfortable, and on top of that, they're putting their patients at a tremendous amount of risk. For a surgeon, for example, if they have an issue in their lower spine and they can't stand for a period of time without having to step back, that's dangerous. The patient's sitting there under anesthesia. They could certainly be open, and the doctor has to take a step back to take a break, or maybe they're having some issue with their hands where their hands are going numb, or they can't feel or have the dexterity in their fingers to be able to manipulate their scalpel or the instruments. That's a very dangerous situation for that doctor and for that patient. So what you often see is the insurance company questioning, well, you've had this issue for a while. You had these MRIs back a few years ago, and you had some other MRIs recently, and we don't really see a big change. We could understand, and we see that your procedures have reduced, or we see that maybe your income's gone down a bit, but we really don't see the justification here for stopping completely. We think you could continue to work. Sometimes they even hire out an ergonomic expert or consultant to come down to your office, right, and see kind of the clinical setting. And for example, with a doctor, look at their operatory, see what chairs they're sitting in. Do they have loops? Do they have headsets they could wear? Do they have light? How's the lighting? And what they try to convince them that they could invest in these products or invest in this type of chair to be able to continue to do their occupation. Because the last thing that insurance company wants to do is put them on total disability. All right? And they'd much rather pay that claim for partial disability. There's a few implications to that. First off, they're paying the benefit based on a fraction or an income percentage or an income loss percentage of that doctor's profits or income. All right. So let's say they have a 30% loss of income. Well, the insurance company may only have to pay 30% of that benefit versus 100% of that benefit. All right. The other issue is that many policies have these lifetime riders attached to them. And if that doctor maintains and continues on partial or residual disability and continues to work throughout, and they cross that threshold, that total disability lifetime threshold, usually it's around age 60, all right? Sometimes it's sooner, but usually it's around age 60, and they haven't become totally disabled by that point, well, then they forfeit their lifetime benefits. They can't be disabled and receiving benefits for the course of their life. Even if their loss of income, let's say, is 75% or greater, they're basically, income-wise, they're totally disabled. They're receiving 100% of their benefit. If they're not totally disabled by a certain point and not working, then they lose out on lifetime benefits.
So, Cesar, the scenario you're discussing is one where a doctor wants to cut back and the disability company basically says, look, you're residually disabled. Take it the next step further where the doctor goes, okay, I cut back. Let's say, for example, it's an orthopedic surgeon. And the orthopedic surgeon says, look, I was doing surgery 2 or 3 days a week, and I don't feel I can do surgery anymore because, we'll use your example, I have a lower back issue. But you know what? I can still do patient evaluations. My practice can accommodate me. I can refer all the surgeries to somebody else. How do you determine then at that point if that person's going to go from partial to total disability, and especially in the case where they may not even have a reduction of income, but they've given up the surgeries? What's the analysis going to be in that situation to prove that that orthopedic surgeon is totally disabled?
Yeah. Well, what they're going to basically look at is they're going to conduct this forensic analysis. Sometimes they farm it out, sometimes they do it in-house, of that doctor's CPT codes or all their procedure codes, right? They're going to look at the number of surgeries they're conducted, how many units, how much income is driven by those surgeries. They're going to look at their clinical duties, okay? And they really can break it down in these CPT codes. I mean, you've got examinations, you've got injections, you've got different procedures and things that are conducted within the office practice itself, within the clinic. And what the insurance company could potentially say is they could come back and say, well, we see that you've in performing nerve blocks or performing these anesthetic type procedures in your clinical practice, you're earning just as much income as you're earning in your surgical practice. All right, and then they put in conflict basically your clinical practice and your surgical practice, where they're making the argument that both are substantial material, that your clinical practice is just as important as your surgical practice. And basically the argument that needs to be made, and hopefully can be established through the evidence and through the procedures, is that your surgical duties are really the substantial material duties, all right, if those are the ones that you can no longer do. Because you have to get back to how much of your practice is driven by that. Your referrals are going to get cut out. Other doctors who would be otherwise referring patients to you may not, because you can't perform surgeries anymore. So you're going to see the overall success and income in that practice go down significantly.
And Cesar, I want to cut in right there, though, when you were talking about is there by law or from your experience a deciding factor? Is it the percentage of money that the doctor was making pre-disability from a particular occupation, or is it the percentage of time that was being spent on those particular duties? Which one is the more important factor, or which is the go-to factor that is relied upon by a disability company to use in this total
and Greg, this is where in each area, in each state, in each jurisdiction, the laws are different. The case law is different. And it's really a factual question. It's not really codified in any statute or anything like that. Every case is unique. Every doctor is unique. Every practice is unique. And in most cases, if that insurance claim is disputed and it's in litigation, that judge is going to say, no, this is a question for the jury to answer, because there's sufficient evidence here to say the surgical practice was certainly substantial and material. Okay, and I think that that's really critical. I mean, that's because they understand that there's not, you can't always fit everything into this tight little neat box that the insurance company wants to fit it in. All right, there's really lots of shades of gray here.
And that's what I wanted the doctor who's watching this to understand, that ultimately it's going to come down to a question of fact by the jury. And 6 people, you never met in your life are going to be the ones who are going to make a determination to say, was this pre-disability duty material versus what you're doing after, is that material? And there's a real distinction to be made, and it can sometimes be a gray line, but for surgeons, especially who are doing surgeries, they're like, look, I'm going to eventually lose my referrals, whatever it may be, the word's out that I don't operate anymore, and the well's going to dry up, per se. So this isn't going to go on forever where I can still see patients, but my life was as a surgeon using my hands and operating on people. And it all comes down to, Cesar, like you said, is an analysis of the CPT codes and a relationship between analyzing how much money you were making and how much time you were spending. And the question I asked you, Cesar, which you answered perfectly, is it really varies, because it's not always a factor of money, because an orthopedic surgeon can make 80% of their money doing surgery, but only spend 20% of their time doing that. So it's really not fair for a disability insurance company to say, well, you only spend 20% of your time in surgery, and we don't care that 80% of your revenue came from that. So those are the arguments that, and we're just talking in generalities, and obviously we've done this hundreds of times with this scenario to argue back and forth between total and residual, but that's probably one of the most common types of arguments that come up for denials of doctors. Of course, you have all of your regular Cesar where they say the medical support isn't there, or we got you on video surveillance and we think that you can do more than you're telling us to do. All the traditional methods of disability, or there is a change in definition of disability from an own occupation to an any occupation type definition of disability. So, or it's just a traditional that the disability insurance company had a medical review done and they just say, we don't think you're disabled anymore. I mean, I just finished an appeal, which luckily I won, for an OBGYN who had a severe cardiac issue on claim for 10 years. Ejection fraction rate was below 25% for the past 10 years. And all of a sudden they had some quack doctor review his file and say, well, he's been stable for 10 years. He's fine. Go back and deliver babies. So, this is a typical scenario, and we could, give examples of 100 different more situations like this, but the options for you are to be discussed, obviously, if you've been denied. And I don't want you as a doctor to assume right away we have to jump into a lawsuit, because the idea of waiting 6, 12, 18 months, the idea of the disability insurance company digging into all this information about you, speaking to all of your doctors, speaking to potential colleagues, it's going to be tempered, but it's always easier to go the road of least resistance, even though we are very aggressive. Cesar, you know that I love to go to trial more than anything else in the world and tear up an insurance company, but I want to get to the quickest point of resolution for our clients, and there are strategies to do that we're happy to discuss. So in summary, if you're a doctor, no matter what your specialty is, we encourage you to give us a call. We'll provide you with an initial free consultation and discuss the options that are available to you. We represent claimants all over the country, and we've litigated these claims in courts throughout the United States. We encourage you to spend a little bit of time on our website, research your company, your medical specialty specifically. You're going to see resolved cases that we've handled, summaries of other cases. You're going to learn from the experiences of other people who've been through your exact situation. We also have references available for doctors in your exact medical specialty that we can provide to you. We want you to feel extremely comfortable with our level of service that we can provide to you, and we want you to know about what the road ahead is to go ahead and get your benefits paid to you and get you back on claim, or get you on claim if you've never been on claim. So we look forward to the opportunity to speaking with you in the future. Thank you.